There is a legal body inside the United States Department of Justice called the Office of Legal Counsel. It appears in no statute that Congress ever passed, and it has issued written opinions that carry the force of binding law on the entire executive branch since at least 1934. You have never read those opinions. Most of them you never will. That should stop you where you are. Because right now, in a building on Pennsylvania Avenue, there are legal conclusions, final, treated as binding law that the government has decided you are not allowed to see. Not because a court ruled that way. Because the office that wrote them decided. The Office of Legal Counsel is not a court. It holds no public hearings. It has no docket, no press office, no public-facing process of any kind. What it does is write opinions, formal legal memoranda addressed to the president, to cabinet secretaries, to the heads of executive agencies, that tell those officials what the law permits the government to do. And once the OLC issues an opinion, it is binding, not advisory. Binding. Every department of the executive branch is expected to follow it. Every cabinet secretary, every intelligence director. Every agency with authority over your money, your communications, your records, your movement. When the OLC says the president may do something, the president does it. When the OLC says a surveillance program is legal, the program runs. There is no external appeal, no mandatory review, no requirement to publish. The opinion exists, the power flows, and you are governed by it. Here is the part that took decades to fully surface. Congress did not create the Office of Legal Counsel as a binding opinion authority. That function grew inside the Attorney General's office through a series of internal reorganizations, formalized not by legislation but by executive directive. The decisive structural moment came in 1950, when the Department of Justice was reorganized under Reorganization Plan No. 2, an executive action, not a congressional vote. The modern OLC emerged from that plan. No senator voted to grant a small team of appointed lawyers the authority to write secret legal conclusions binding the entire executive branch. That power accumulated through use, through procedure, through institutional habit, and by the time anyone named it for what it was, it had already become the architecture. The person who runs it carries the title of Assistant Attorney General for the Office of Legal Counsel, nominated by the President. Confirmed by the Senate, but confirmed only as an Assistant Attorney General. The Senate does not vote on the OLC's opinion-writing authority. It does not vote on which opinions stay classified. It has no formal legal mechanism to compel the release of any opinion it has never seen. The confirmation happens. The official takes office. The opinions accumulate, and most of them stay inside the building. Remember, no one voted for this. Now here is where it reaches you. In August 2002, the OLC issued a memorandum, later known as the Bybee Memo, authored by John Yoo and signed by then Assistant Attorney General J. Bybee. That memo legally authorized interrogation techniques that the Senate Intelligence Committee, after a decade of investigation, concluded were torture. The program ran for years. The people operating it were told, in a formal written legal opinion, that what they were doing was permitted. The opinion was the law. And you were not allowed to read it. That is not ancient history. The OLC issues opinions today on executive power, on the scope of surveillance authority, on what federal agencies may do inside your financial records, your digital communications, your medical data. Some of those opinions have been placed in a public reading room, many have not. The OLC's own disclosure policy says it will release opinions when doing so does not harm the public interest, and the OLC determines what harms the public interest. And here is the part that should actually worry you. This is completely legal. There is no statute requiring the OLC to publish its opinions. There is no law granting Congress automatic access to them. The Freedom of Information Act contains Exemption 5, which shields internal legal deliberations and attorney-client communications from disclosure. Courts have upheld that exemption consistently. The structural lock is built into the same legal framework the OLC interprets. The body that defines the boundaries of executive authority also defines what must be disclosed about how it defines those boundaries. That loop does not close. It was constructed not to. What this tells you about every institution beneath it is straightforward and hard to dismiss. The OLC is not an accident. It is a pattern. A function grows inside an existing authority, accumulates power through use rather than authorization, and eventually becomes indispensable. Once indispensable, it becomes effectively unchallengeable. Courts defer to it. Congress has no reliable access. Journalists file FOIA requests and wait years. And the opinions keep layering, a body of secret law, written by unelected lawyers, authorizing the conduct of the most powerful executive branch in the world. The question that stays with you after all of this: if a government holds a legal opinion that determines what it is permitted to do, and that opinion is never published, is the law still public? Or are we already living under something else, something that simply looks like law from the outside and always has?